Live streaming is on.
Welcome to our webinar today. We're going to get started here just in a few minutes. We're going to let people join in on us with us, and we'll get started here in a few seconds. We have a great panel today of some awesome knowledge in compliancy and cybersecurity. But look forward to educating you guys on why compliance and cybersecurity is different and what is new in 2022 when it comes to HIPAA compliance. All right, guys, we'll get started here in about 30 seconds, and we will be sharing with you today. We're going to be talking about the new and critical changes to IT security, the insurance coverage, and HIPAA compliance that will put your practice at serious financial risk if not addressed this year. It's something you're definitely going to want to stay in and to listen to, and we have some awesome special offers here at the end as well. We're going to give it about another 10 seconds here to get started, and we will get going. All right, guys. Well, thank you so much for joining today. This is a webinar is based on the new critical changes in IT security, insurance coverage, and HIPAA compliancy that will put your practice at serious financial risk if not addressed this year. My name is, I'm your host. My name is Will Nobles. I am the founder and CEO of Vector Choice Technology Solutions. We're an IT, cybersecurity, managed services, and compliancy company providing you all the IT needs that you need to have. Now, today, why are we sharing this information with you today? The information we're going to share with you is particularly important to anyone that is managing a small medical practice, that is even supporting medical practice, such as IT providers. Yes, this is for IT providers as well, to understand exactly what you need and what you need to have in place to properly make small and medium healthcare providers secure and compliant. And then, how about if you're a doctor and you're getting to the point to say, hey, I want to sell my practice, I want to move on and get the best valuation I can. This is also for you, is help you set yourself up with the proper compliance so you get the valuation that you want out of your company as well. What's very important overview here: the changes in how medical information is perceived, stored, and transmitted, the changes in HIPAA fines, insurance issues, credit card penalties, and yes, we're even going to talk about credit cards here today. I know we're talking about HIPAA, but PCI, all of us take credit cards when it comes to checking patients out. And then obviously the privacy lawsuits that are out there that can scare you a little bit. Matter of fact, I just was reading up on a little bit. We have an office in Baton Rouge, Louisiana, and I was reading up that the Baton Rouge hospital, General Hospital, got attacked with a cyber attack. And it was actually ransomware. And you might be on this call saying, hey, you know what? I'm not a hospital. I'm a medium private practice. But, you only hear about these big attacks on the news because they're publishing it. They have to publish it. And by the way, you have to as well legally. And we have someone on this call today to definitely convince you that you should. But you don't want to have to go out. And I'm sure Baton Rouge General would not want to have to talk to the news and publish this out. And they rather hindsight 2020, they're probably thinking, God, I wish I was actually protecting myself better before I actually got attacked. But the number one security threat is end users and your employees. And we're going to be talking a little bit today about how to curve that mentality of end users and employees causing you major risk and major fines within your company. So what are you going to learn today? You're going to learn what makes 2022 fundamentally different than the past 20 years of HIPAA. I know all of you guys, including myself, we're tired of the word HIPAA and the acronym there. But we really want to talk to you guys today about what's so different this year compared to last 20, and then also how HIPAA, EPHI, credit cards, and ransomware all overlap, and also how cybersecurity is different than compliance here. And then also small steps you can take that has the biggest impact on your to preventing a loss. These are little things that you can do. And we want to give you a little food for thought here on little things that you can do for that as well. Now, let me tell before we get started here today, let me tell you a little bit about Vector Choice. I have the honor of coaching and leading a awesome team here at Vector Choice. We're in 7 locations, and we've been lucky to make the Inc. 5000 the past, oh, by the way, 3 years in a row. I know you only see 2 there, but technically I can't announce Inc. 5000 until August. But hey, some of you might be watching this webinar after today anyway. We've also made the top 501 MSPs, managed services providers in the world. We were number 111 this year. And then we also have gotten several other awards of being an excellent managed services provider. So what do? We do managed services. We do the traditional. We'll take care of your computers, your servers, your network. But most importantly, what we're going to be talking about today is how we help you from a compliancy standpoint maintain compliance, how we can take our cybersecurity and IT approach to things and use compliancy to take it to the next level and make sure that your company, regardless if you're healthcare or anything else that is mandated by compliancy, will help you keep you compliant. So a little bit more about Vector Choice is we have offices in 7 locations. I'm here in Atlanta, Georgia, which is where our corporate office is at. And then John DePero that's on the call, he's down in our Florida location. And Bo Dickey, that's on the call, which is our chief security officer. He is in our Mobile, Alabama location. But we have locations all the way to Philly, all the way to Baton Rouge, Louisiana. We service clients in 23 states, and we help customers with compliancy and HIPAA, CMMC, ITAR, PCI, SOX, and GDPR. We have clients, international clients throughout Costa Rica, the UK, Netherlands, and the Dominican Republic as well. All right, so guys, enough of Vector Choice and who we are. I wanted to get a good baseline, but let's talk about the brains in this presentation today. And Mr. John DePero, my chief compliance officer that I recruited away and brought in to help Bo build our SecOps or security operations team. John, thanks you so much for coming on today.
It was very much our pleasure. Look forward to another good discussion around compliance and security.
So, John, tell us a little bit about, I mean, you've got an unbelievable background. Tell us a little bit about your background.
Yeah, so I spent the better part of 2 decades working in security and by extension compliance as a soldier in the U.S. Army. I was a counterintelligence agent. I wound up retiring as a chief warrant officer and the special agent in charge of a couple different investigations teams. But I got to work at unique places like the NSA, and I was honored to be selected to be one of the founding members of the first NATO cyber defense working group out in the Netherlands, where we tried to bring cyber defense to NATO a few years ago. So I got to travel a lot, meet a lot of different people, deal with European issues, US issues, all kinds of stuff. And now what I'm trying to do is help clients in small and medium business kind of take advantage of some of the lessons we learned in the massive industrial DoD, the beast that is DoD spending, and take some of those lessons learned and those tactics and techniques and procedures and bring them down to small and medium business, which is really the heart of our economy in our country.
No, John, appreciate it. And thank you so much for being on today. And obviously, thank you for serving this great country. Miss Jennifer Morris, we've got a partner from Taylor Johnson Law Firm. And Jennifer is a compliancy attorney, amazing background. I had a privilege of speaking on stage with Jennifer last week at an event. Jennifer, thank you so much for being on today.
Happy to join, Will, and thanks for the invitation. Just to give you a little bit of background about me, I've been practicing law for over 22 years. I focused my entire career around compliance with complex sets of regulations, government regulations primarily, whether it be in the healthcare environment or government contracts generally. So I'm all about compliance, and I always have been. Like John, I have background. I was an Army officer in the United States JAG Corps. And I started the CIA. You can probably see the seal above my shoulder there. So I've had interesting experiences as well, serving as an intelligence lawyer. And then I practice in private practice. I years inside IT companies, so I'm very familiar with how to help and prevent cybersecurity, cyber risks. I'm serving IT companies and helping to address the exact risks that many of either the IT providers or the customers they are facing.
Awesome. Thank you, Jennifer. And we also had one other person that was going to try to be on the call with us today, and but she got pulled away. Unfortunately, doctors. It happens to doctors, but Dr. Amy was not able to be on the day to share the healthcare side. But I think we've got enough brains on the call today to help educate you guys on where you guys need to be from a compliancy standpoint, and also in the background here, we have Mr. Bo Dickey. Bo is our chief security officer here at Vector Choice. And Bo, do you mind sharing a little bit about your background as well?
Yeah, thanks, Will. I have worked not quite as impressive as John and Jennifer, but I have law enforcement experience, done criminal investigations, doing data forensics, going through sitting in court cases, appearing in courts as subject matter expert on digital forensics, information technology, anything that pertains to what a computer or mobile device can be used in the commission of a crime. Or to provide evidence to verify where a person lives or is working and operating.
Awesome. Thank you, Bo. Appreciate it. So John, I'm going to start with you. The question is why now? Why are we talking about compliancy in 2022? Why are we talking to healthcare companies today that quite frankly, they've got a huge change to make in what they're doing from a practice standpoint. So, John, if you don't mind jumping in and sharing a little bit about that.
Absolutely. Security, compliance, it's all about identifying and managing risk and selecting a risk level you're comfortable with. Sometimes that risk level is selected for us, like with HIPAA laws or insurance underwriting documents. What's different today than in the past is if you're a small practice and you simply looked at it as a risk cost reward model and said, Health and Human Services issues probably 20 to 30 fines a year against small business. That's nationally. Out of the thousands and thousands and thousands of practices, 20 or 30 fines just from a straight, forget compliance and legal issues. I know we got a lawyer on, but forget the lawyer stuff. Just from a risk cost benefit side, you were never going to get hit by a HIPAA, police, if you will. And that is just mathematically a true statement. What's changed now is the fact that the malicious actors, the hackers, have realized that the big hospitals spend millions of dollars in cybersecurity, and the small practices are doing very little, if anything. Yet the medical records they have access to are just as valuable, and they're for sale in the dark web. Forbes has the price at about $1,000 a record, not a breach, per record. So you have malicious outside actors trying to literally steal it. You then also have an inside threat that is new. And when I say steal, let's back up. It's not just your patient records. Most insurance carriers are now requiring practices to keep a credit card on file. When you look at the terms and conditions, and I'll let the lawyer talk about that kind of stuff later, but when you look at what you agreed to do when you started taking credit card payments or Visa, MasterCard, whatnot, you agreed to a certain security standard if you store the card, if you take the card, if you transmit that information. And I would argue that the vast majority of small practices never really read the fine print of what they agreed to when they started taking credit card payments. And they just don't understand the financial liability that they're carrying every single day by taking credit cards without having read through the liability and the security agreements. The third piece is the kind of the insider threat. Good people make bad accidental decisions, right? We click on links we weren't supposed to click on. Through no ill will, your own people can just make a mistake that puts you at enormous risk. And we typically see that small practices have nothing internally to control the damage or to limit how bad a mistake that can be. But there's a malicious side to the insider threat too. If you accept Medicare, Medicaid, if there's a million different scenarios where you've gone on record saying, I will conform to all applicable laws and regulations, whether it's the electronic health records initiatives from Medicare, Medicaid. Almost every state has a state information security requirement. And most doctors' offices, the office manager, whoever's setting this up for you, just kind of signs all the agreements when they submit for payment. You're going on record to a government saying, I will comply with all federal laws and regulations or state laws and regulations, HIPAA being one of them. So if you have a breach, if you have a disgruntled employee who simply calls the inspector general, you're literally guilty of fraud if you knew that you weren't securing your environment properly because you just figured, the HIPAA police will never get to me. I know none of the folks on this call were thinking that. Otherwise, they wouldn't be on this call. But it is a common mindset that I see that people are so focused on the fact that they don't think they'll ever get fined, which is you're right, fraction of a percentage of a chance, that they're just completely not even thinking about the civil lawsuits. And I'll let Jen talk about the difference between negligence and malpractice and duty of care, right? Kind of cue her up. But if a jury of our peers is sitting there and they say, well, what was that doctor doing to prevent this? If you can't answer that saliently, it's going to be a bad day. And it's not going to come from offices of Inspector General or Health and Human Services. It's going to come from sorry, Jen, an ambulance chasing lawyer, who's going to file a civil action over a breach or records being delayed, or they asked for a copy of their x-ray and it took longer than your state allows because they were waiting till you got a ransomware knowing you would never get the x-rays to them on time. And it's not hypothetical. Literally hundreds of cases a month. And we can point you to some examples in every state in the union. The civil actions from credit card companies, from patients, from former employees vastly outweigh the financial risk you face from Health and Human Services.
Yeah. Awesome, John. Appreciate it. And for everybody, if you have any questions, please feel free to put it in the chat, and we can get to those questions for you as well. Jennifer, your thoughts. Why is compliancy so complex and so different in 2022?
Well, I'll start by playing off some of what John mentioned. I mean, absolutely, anybody who signs a form to a government agency that says, I'm going to do A, B, and C to protect the information that I have, the PHI, the PCI, for any process is liable. And whether you knew that your manager signed it or not, you're still liable. And if you weren't actually compliant, you're going to be found negligent. And there's lots of civil lawsuits, as John said. We won't get into those. Lack of awareness is not a defense. So the civil lawsuits are not even your biggest risk, and that's probably not what you wanted to hear. The bigger risk is the fraud allegations. John mentioned how disgruntled employees can really do some damage by calling an inspector general. Well, there's a whole slew of legislation related to fraud that what's called a key tam case. It's a whistleblower who can go to the federal government because you're doing business in healthcare and you're governed by HIPAA and say, my company's not doing things properly, they're committing fraud. If the Department of Justice picks up that whistleblower's case and looks at it, it's going to be a False Claim Act case, which is a civil or criminal false claim case, depending on the nature of the action. And that whistleblower is entitled to a percentage of the case. So they're motivated to go to DOJ. And the worst part about the False Claim Act is it's a very tough statute. So it issues treble damages for every claim. So let's say you filed 100 claims. It's $11,000 minimum fine per claim times 3 because it's treble damages. You can see how those damages add up very, very quickly. And for small to medium practices, that could be a devastating practice ending event. So why is it important to get in front of compliance? Because you don't want to have one of those. I mean, the big guys can handle some of those risks and maybe handle 1 or 2 of those allegations and survive some of those suits. But small to medium companies generally can't. I've seen companies get put straight out of business because they're attacked by DOJ and they just can't afford to pay the fine. And that's it. They're bankrupt for that.
And the
So
scary
Jennifer,
part,
what
there,
you're
Will,
saying is,
well, just to add one
Go ahead,
thing,
John.
sorry. The scary part is you don't have to have a breach.
Correct.
You don't even have to have been hacked. You just have to not be dotting all your I's and crossing your T's for compliance and have an inside somebody know that you are
In fact,
misrepresenting your level of security or policy or training or any of these 700 pages of HIPAA requirements. Doesn't even have to be from a breach.
absolutely. In fact, DOJ has set up an entire cyber initiative focused solely on people who are not meeting cyber requirements where they've attested that they are. And so one of their first cases was a healthcare provider. The healthcare provider never had a breach, but they were backing up their systems on a third-party provider, and that third-party provider was not compliant. They were charged with a violation under the False Claim Act, and they settled the case for $933,000. That was the first of many investigations DOJ did. The next case, signed only earlier this month, a few weeks ago, was a $27 million case where a company signed that they were in compliance with the cyber requirements for governing their business. And in fact, they weren't. They had to pay a $9 million fine. And that was to settle the case.
So 2 days ago, the SEC, which I get SEC is not healthcare, but they just paid a whistleblower $17 million to the whistleblower. That's not what the company got fined. That was the whistleblower's share. So if you don't think that this is spawning a sea of attorneys who smell blood in the water around whistleblower claims, and the same thing across credit cards, you get a credit card breach. Anytime there's credit card fraud, the entire world looks to push the responsibility for that downstream. Visa has a sea of lawyers, and MasterCard and all the, I'm not picking on Visa. They have a sea of lawyers who've written their terms and conditions very deliberately. Those go to the big credit card processing companies, the ones who actually provide you that machine. They have a sea of lawyers who've written these things. Do you know who doesn't have a sea of lawyers who's gone over this? The guy at the bottom of the totem pole, which is the practice, the dentist, the physical therapist, just that guy or gal who just said, oh, I guess I got to be able to take credit cards now. So they just signed up for a service. They can hit you with fines, astronomically high fines. They can stop you from taking credit cards. They can double your transaction fee percentage. I had a company go up to 8% over a breach. That's a big difference in profitability. So we have to stop looking at the problem, Will, as will the HIPAA police get me? Because you're just not paying enough attention to what's actually likely to get you. But they'll leverage the fact you're not compliant.
Yeah, so what I'm hearing both of you say, it's not Big Brother, it's not HIPAA, it's not the government that's going to ultimately hurt you. It's probably going to be the patient, a whistleblower as an employee, or just being very negligent of doing business.
Yeah, I mean, I think in my case, the whistleblower leads to the Department of Justice, and that's where the government comes in and really, really hammers you. I mean, a criminal False Claim Act case is the worst case scenario. CEOs or presidents of organizations go to jail. It's a very serious allegation, and the fines are astronomical.
Well, great, guys. So let me ask another question, sort of to play on the compliancy, and John and Bo, you might need to answer this more than Jennifer. But what is the difference between IT, cybersecurity, and compliance when it comes to your IT provider or your technology specialist providing those three different categories to you?
At a high level, you can put it in three big buckets, Will. There's the planet, which is the business function, right? That's the leader of the company saying, I want to have my entire data network backed up once a day, and I want to be. If I'm down, I can only be down for 2 days before it affects my business. There's the planet. That's the policies, the paperwork, the acceptable use agreement, all that stuff in the paperwork side. Then there's the perform it, and that gets into the actual security stuff, like what Bo does for us. They put all the tools in place to prevent an attack. Security, when we talk about security, we're talking about something we do to prevent a change in our current state. Like this is where we're at and this is where we want to stay. So, and I'll let Bo talk about the different techniques, but security is to prevent someone from changing this. The last P, to borrow my buddy Rusty's 3 Ps, is prove it. That's where compliance really comes in. We take standards, whether they're external, like HIPAA, Visa, MasterCard payments, or internal, like the CEO of the company saying, I cannot be down for more than 24 hours if I get hacked, or if my server gets hit by lightning. It could be an internal standard like that, right? I don't want my receptionist to be able to get into my business files. Like that's a standard, right? So the prove it is where we put trackers, where we put reports, where we do presentations to leaders to say month to month, quarter to quarter, year to year, this is where you sit. The plan was where you wanted to be. The proof is where you really are. And I'll tell you where that's most important. Yes, it's important for business leaders to know where they're at any given time. But when you have a breach, you didn't have it the day you found it. The breach happened months earlier, right? So when you file that cyber security insurance claim, and they come and they before they write the check, they're going to send a forensic auditor who's going to look at it, and they're going to say, well, it was Jennifer's account that got breached. And terms, your underwriting says you will have MFA enforced. That's multi-factor, or some people say two-factor authentication. You'll see that on almost every insurance form now, underwriting questionnaire. They're going to go back and say, prove it. We don't think Jennifer's account had multi-factor authentication turned on. Well, the solutions that we set up in a mature compliance solution, every single month we're running the audits and the reports to demonstrate that everything you said you were going to do is being done. So 6 months later, when an auditor comes, you're not scrambling, looking, trying to create old artifacts. You just have them right there ready to go. No different than if you got audited by the IRS. If you got audited and they came asking you for 2-year-old receipts, if they're not sitting there in a folder ready to go, you didn't have the receipt. Then that's a no, right? Same thing with cybersecurity. If you don't have the receipts 2 years later, 6 months later, whatever it was, then you weren't doing it.
And John, those artifacts are the same things that will help protect you in the event of a government investigation, a civil lawsuit, or anything of that nature. Because that cyber insurance company that's looking for the receipt, they're trying to not pay your claim. So you want to be able to show them that you didn't have cyber negligence. You did, in fact, have the multi-factor in place.
And so it sounds like IT is sort of the function of doing the work, as what a lot of companies are traditionally used to. Cybersecurity is actually taking that next step of protecting beyond a firewall and antivirus of cybersecurity. And compliancy is really verifying and producing that something was actually done.
Absolutely. And Will, this stuff is hard, right? Especially for small businesses. Speaking specifically around medical, you're expected to be an expert in your field and do continuing education and recertify with your state board that you're good at what you do, right? Oh, and then you're supposed to understand how to borrow money to get a new X-ray machine and how to have the right IT security and right the E&O insurance policy for like it's hard to run a small medical practice. It's very hard. That's one thing we try to do is come in and help people say, look, I don't expect you to be expert in all these things. Let's form a team of teams to help you at least think through these questions. If we talk about X-ray machines, how do you know your X-ray machine is secure? Your IT company didn't give you the X-ray machine. Your IT company doesn't support your X-ray machine. It came from another IT company, right? Or your electronic records company, or your medical billing company. There's all these different pieces and widgets. In Florida, the owner of a healthcare record is the practitioner who created the record, not the patient itself, not the X-ray company. So the doctor who creates the record in Florida law is the owner of that record and is therefore responsible for securing it. So it's one thing to say, well, I use this cloud service for my stuff, I'm good. That's not what the court's going to look at, right? Or to say, well, my X-ray machine, I'm sure it's secure because they do this all the time. I wouldn't leave it at that. Nor do we have to spend 30, 40 grand trying to secure an X-ray machine. What we just want to do is have that first piece, that plan it, right? What are the policies? What are the business agreements? Let's get it in writing from the X-ray machine that they're going to be compliant and assume all responsibility for their piece of the pie. And if you don't have those pieces of paper in a little book ready to go with your lawyer or your security partner, then they don't exist. That's another form of evidence that just doesn't exist when you go to need it.
And Will, if I could just add something, I'm not nearly as smart as John and Bo on all the technical security, cybersecurity pieces. But from my perspective, I think that the biggest and most important thing about compliance is a company culture. If somebody says, oh, I've checked all the boxes and therefore I'm compliant, but they don't really adopt the practice and they don't live it and breathe it and train their employees with it and encourage all their employees to adopt a culture of compliance, then it's useless. Because compliance is only as good as the people that work within the program. I mean, we can create a solid compliance program for any company, but if it falls apart the day after we create it, it's no good.
I agree with Jennifer and John here. The big portion of this is that the policies and procedures exist, they're followed, and they have to be followed from the top down. It's got to be a company-wide culture. It can't be, oh, well, the CEO's excluded because it's inconvenient or it's hard to follow these security practices. It's hard to do these IT practices. You know, everybody's got to be on board with it. Did we lose Will?
I think we might have lost Will.
Well, while he figures that out and comes back in, and that gets back to what Jennifer said and what Will kind of added too, is if it doesn't exist in a physical documented form, then you didn't do it. You know, when an attorney is, I'm sorry, let's go like another discipline like real estate agent, right? When a real estate agent gets hacked, and they have lots of financial information about clients, right? Oh, I think we got Will back. When a real estate agent gets hacked, if they're standing in front of a jury of their peers, all your friends and neighbors, right? They get to say, look, I don't know this stuff. I hired a company. I hired this managed service provider. They said it would be secure. I went on Microsoft's website. They said I can prevent ransomware. So I bought all this stuff and it still happened. I think a jury of, you know, our peers listens to that story and says, yeah, that kind of makes sense to us, right? It's different for doctors. Doctors have a 20, almost pushing 30-year-old law that says you will secure it. It's your problem how. This it has to be portable, it has to be protected. You kind of don't get to say, well, I really didn't know I was responsible for protecting it. And not to belabor the point, The world's figured out how to monetize the fact that you're not compliant. And I mean the world outside the HIPAA police. And if we don't get ahead of it and start creating those documents and start creating all those artifacts for you so that you're ready, it's not something you can do at the moment of a breach or at the moment of a lawsuit. They have to have been in place for months and months and months to demonstrate that you've been doing it the right way or the best you can. Or I'll let Jennifer fill in the blank, but like what would be called reasonable due care, I think, is the big HIPAA term, that you're providing due care, because it touches on the quality of care. What's the term we have to do for doctors, Jennifer? The quality of care. That's the difference between negligence and malpractice and oops, I made a mistake, right? We want to stay out of the malpractice negligence field.
Yeah, and I mean, I think when we're talking about IT security and insurance coverage for, IT security breaches, you're absolutely right, John. HIPAA's been around forever. And, a lot of we deal a lot with companies that do direct business with the US government. And maybe some of you do direct business with the VA or with HHS or CMS. But the US government has layered on all these relatively new cyber requirements and information protective guidance. And so there's a little bit of argument, at least I would argue to the mat that there's definitely argument that it's new and we still needed time to comply. But it's harder to argue that with HIPAA. If it was really something that should have been complied with 20 years ago, it's harder to overcome that hurdle.
So Jennifer, and this might be a question for you as well, is when people are, a lot of doctors are hesitant of spending money on high tech. It takes right out of their paycheck. It's a lot of headache. And we saw, several years ago that a lot of doctors said, hey, I'm selling, I'm retiring, I'm not dealing with this headache. What from a legal standpoint, to really convince the practice administrators are on this call, or practice executives or doctors on this call to say, hey, you've got to spend money on high tech, like compliancy, cybersecurity, or you're not going to have a practice. What do you say from that?
Sure. I mean, well, I see that a lot. I sit here in DC and I see that a lot, even in the DoD and federal government contractor space with small companies that have to make that choice. Everybody's here in the revenue business, and at some point companies make the choice of, am I going to be compliant or not? And, it's a choice that companies individually have to make. As a lawyer, my concern about how you make that choice is what I call the parade of horribles. In a worst case scenario, if something goes awry, can you sustain that $2 million False Claim Act charge? Can you sustain the litigation costs from the credit card company and the people whose information got stolen? Because they're all going to sue you. If the answer to that is yes, then maybe you're in an acceptable risk position. If the answer to that is no, because your insurance is probably going to try to find a way out of some of it, if not all of it, then you're in a make or break situation. And that's where the risk scale tips. So, companies like big government contractors and big healthcare providers, they can afford to sustain millions and millions of dollars in lawsuits without going under. But for the small to middle-sized companies, that's just not a reality. And none of us here on the panel can really decide that for you, but ask yourself that question. What is my parade of horribles? In a worst case scenario, where do I have to draw the line in the sand where I can't afford to take that risk? So it's real easy to say, I don't want to spend the money on compliance. I don't want to go high tech. But then do I want to lose everything? Because you're probably personally guaranteed on many of the assets, many of the loans and the financial documents. So you will not only lose your medical practice, but anything you personally guaranteed. Maybe that's your house. Maybe that's your personal bank assets. I mean, these kind of things are situations to be thought about carefully.
So another piece of that is kind of piggyback on something Will kind of put out. Extremely short version of a much longer story. The way I actually kind of got to know Will was actually through other work I was doing, working with mergers and acquisitions that also Jennifer works on too, right?
Yes.
And it was practices that were selling, independently owned practices, all of a common discipline, that were selling to a PE firm that was buying them up, standardizing the IT, right? Standardizing the business practices, the billing, everything. And then the goal is, once they got to a certain number of practices, package it up and sell it as a functional turnkey, medium sized, if not large sized business. So IT has two roles. One is IT is a thing that you're buying too. Are these computers like from Best Buy with Windows 98 Home Edition and they're all going to need replaced? Or do you have like high quality computers? That's no different than your x-ray machines or your different medical instruments that you may have. If it's old, it's not worth much. If it's new, it's worth something. So that's fine. We can understand that. But what I was coming in with the venture capitalist groups was that they realized quickly that the value of a company that has had a horrible HIPAA compliance for years, the moment they own the company, they assume risk. So two reasons. One, when you are a owner operator, maybe one or two doctor little practice, we all agree HHS is not statistically going to come for you. That's not a promise, but statistics say they won't. But now if you're a 40, 50 location practice and you're worth hundreds of millions of dollars, then they will. And they only got to find one of your offices not compliant. So they started asking me to come and do a gap analysis of how far away from compliant all these different offices are. And the ones that it was what we call a soup sandwich, their valuation plummeted. We had PE firms ready to buy the company, but because they could not demonstrate even a moderate attempt at HIPAA compliance, we would either not buy them or give them significantly lower amount. So I would argue, if you're interested too in selling your company practice in the next few years, or at least being positioned to sell, the ability to demonstrate a high level of portability in your IT, whether that means modern infrastructure, whether that means secure storage, whether that means documented HIPAA compliance, it will absolutely drive up the value of your practice.
So,
And
John,
Oops.
go ahead, Jennifer. I'm sorry.
I was just going to say, I can piggyback on that. I think it's not only if you're looking to sell, it's also if you're looking to buy. As a lawyer, I've been on both sides of the M&A transaction. So if you're a private equity firm, they send in people like me to look at your contracts, your compliance, any risks you've had, any suits you've had. I can tell you that a past suit for a fraud allegation is really bad on a due diligence finding. So that's going to affect your valuation. It's going to affect a buyer's potential interest. A whole mess of contracts that aren't well organized, your files aren't good, your policies aren't good, it's going to downplay your valuation and affect a buyer's interest. Similarly, if you're thinking of buying a firm, don't forget to look at those things. Make sure you have somebody that goes in with that in mind, because you don't want to take on the risk. What if that company got charged last year with a fraud violation by the Department of Justice and you just didn't know it? That's a big risk for you. So it's good to have people that can think about that risk on both sides for you.
Yeah, good point, Jennifer. So my next question for you guys is, let's talk about after something happens, right? After a compromise happens, how important is it to have a mature security compliance program in place if you're a small practice after the compromise? How important is that? From Jennifer, I'll start with you from a legal standpoint. How important is that?
Well, everybody, probably from a cyber perspective, they have cyber insurance. But what that really does is doesn't mitigate your risk. It transfers your risk to someone else. You've paid somebody else to pay for some of your costs when there's a cyber event. The best way to mitigate your risk, in fact, the only way to really mitigate it when you're in that situation, is to have really good agreements and really good compliance. And your first phone call should be to a lawyer, because the best number one tool to help you is the attorney-client privilege. It is the number one thing that can help you. You want to keep everything about that breach under wraps as much as possible, non-discoverable. You want to teach your employees not to say anything. You want to have, the cyber investigator and the insurance firm, everybody on the phone with the lawyers. And I don't mean that just to, upsell services. It's to protect you, the company.
So you mean my first call shouldn't be the insurance company?
No. No, because often, I heard this when we were in Nashville. Will, somebody said, well, I'm just going to call the insurance company and we're going to use their lawyers. And I was like, that's not necessarily the best way, because the insurance company has an interest opposed to yours. They are trying not to pay your claim. So their lawyers aren't necessarily looking out for your best interests. You want a lawyer that's in your back pocket, that's looking out solely for your interest, that can protect everything that's going on under the attorney-client privilege. And what happens, everybody's scared and everybody's stressed in a data breach. And so an attorney-client privilege conversation and brainstorming session becomes the only safe space where all the parties can actually talk openly. So then media communications, outreach communications, any notices that need to go out, they all get run through the lawyer to make sure that nothing is getting inadvertently said, no accidental admissions of guilt get relayed, because then you're minimizing your risk with each of those steps. You're carefully communicating what happened. You're not opening yourself up by accident to those civil lawsuits. They're going to come anyway, but the last thing you want to do is have some employee have said, oh yeah, we forgot to do A, B, and C. And now that's out there.
Yeah. This question is for any of you guys. A lot of people, a lot of practices, when we talk to them, they say, well, my EMR is in the cloud. My data's in the cloud. It might be with another provider. What is the responsibility of that private practice, even though that their EMR might be in the cloud, to still maintain compliance and cybersecurity inside their practice?
So at a very minimum, federal law requires that you have what's called a business associate agreement, or a BAA, in place with everybody that you do business with that handles PHI, or ePHI, which is the electronic form of PHI.
Mm-hmm.
So if you're uploading your patient information into a cloud-based service, that's fine. It's actually, they want you to, right? Medicare, Medicaid will pay you more to start modernizing how you process this. You simply have to have the BAA signed between both parties. And at a high level, what it says is, we are going to comply with everything HIPAA makes us protect and report, and you're going to comply with protect and report. So for every one of those BAAs, and they're bi-directional usually, where if I have a problem, I'll tell you about it. If you have a problem, you'll tell me about it, right? They all have to be signed. The company that you lease your x-ray machine from, the company that provides your electronic health records. But I would also look at any of your providers that might have access to PHI. Maybe the company that runs your security cameras, if you're not deliberate about what they can, maybe the camera can technically see video screens or who's coming in and out. Maybe they need to have a BAA on file, right? So have a compliance person help you walk through this. And how hard is it to just get them all, have them on file, have them ready to go? And this talks back to Jennifer's point. You have your cloud service, which is your original question, right, Will? And I have my BAA. Take Microsoft, right? You can use Teams for HIPAA compliant Teams. Microsoft has a guide for how to do it, and they have those BAs online. You just download it, fill in your company information, and Microsoft will enter into a BAA with you. Totally fine, right? But when you read it, if you have a breach, if they have a breach, we're supposed to bi-directionally tell everybody else who's been potentially affected, right? This gets back into tell your lawyer. What are your requirements to your cloud-based provider to let them know that one of your employees may have misclicked a link, right? I hate to say it depends, because that's not helpful, but you absolutely have to look at those business associate agreements to include your cloud service to make sure that in the event of a reportable incident, that you're communicating to them in a timely manner. And should you pick up the phone and call them? No. You should pick up the phone and call your attorney, right? Who will walk you through all the people you need to contact. And if you have a mature system in place, right? And I'm not saying Rome was built in a day, but a mature system, you have like a book ready to go that's printed, that's offline, because maybe it was your computer that got like encrypted. It's offline. Your attorney has a copy. You have a copy, and I call and I say, Jen, I just had a bad day. And she's like, I got you. And then you walk through. You have very rigid timing reporting, right? You got to get that first call in to Health and Human Services. We had a breach. We don't know the details yet, but we did have one. And you let your lawyer navigate that process with you. And this, again, is that difference between standing in front of a jury of our peers saying, I did everything a reasonable human would do, versus I just assumed it would never happen.
So, John,
Hold on, Will. I want to
Okay.
piggyback what John's saying here.
All right.
The reason that those pieces are important is that from the security portion of that, everybody goes on high alert when an incident actually happens, right? Everybody's in panic mode. Having that documentation, that process laid out with the attorney who's already practiced in this, it makes it so your security team on your side knows exactly what to do step by step. There's no thinking required, so it makes it harder for the human error aspect that could damage your own defense in a court law.
You've put some third parties in place because everybody's emotions are firing. And so you've put some third parties which help calm the situation down.
No, good. I think good points all around, guys. Definitely. So we're coming up on a close end of time, and I think I've got two more questions I want to ask you before we're finishing up here. Is should a IT provider be doing this for their clients already? Meaning, a lot of times, you're my IT. I thought you were handling that. Where's that defining of a traditional IT company and when a company has a compliancy cyber approach to business?
Yeah, so very briefly, a lot of these decisions were made when you signed up your deal with the MSP, your IT company. You made these decisions a couple of years ago, and then we've just kind of been band-aiding things as the world changed. And like I said, I'm not criticizing the decision from 3 years ago. Like, on simple math, it was probably a very sound decision. Not that I counsel you to do something illegal, but just on the risk reward, the 3-year-old decision made sense 3 years ago. What I'm purporting to you is your MSP, whether it's vector choice or not, these are the decisions, the discussions we should be walking through you with every client, specifically in the medical field. How do you want this to go? If this happens, who's doing what? And it doesn't have to be start with an hour once a quarter to go over a new topic. There's some things you can do pretty quick that have a big effect. That you'll get a lot of benefit with a little bit of effort, right? And in a smaller cost. And the big long-term stuff that maybe is expensive or takes new hardware, takes time, put that on a roadmap and plan for that in the future. But there's a lot you can do quickly, but you need a partner that actually understands the security piece, the compliance piece, and the legal reporting requirements. Every MSP should be having these discussions with their clients. I don't run your X-ray machine, but I know how to talk to you about having a process for it.
So
yeah, good point there, John.
With what John's saying, from the high level overview perspective, the IT are the tools to do business. The cybersecurity are the enforcement of policies that are coming from government or whatever regulatory pressure that you're under. The security is making sure that those pieces are in place and that those are applied to those tools. And then the compliance is John essentially telling me, hey, this needs to be done. Figure it out.
And it's the written corporate policies. I mean, compliance, again, is back to the what have you got? What are your artifacts? How can you prove it? Where do you show it? And what's your culture? Are your employees living by it? And then in a worst case scenario, do you have an attorney on speed dial who's ready to help you?
So, and the one thing I would caution you against, so that a doctor gave me this analogy, Apparently, doctors have an emotional response to patients who came in and said, "Don't worry, I went on WebMD. I know what to do here." Right? Um, I have the same response when doctors tell me, "Don't talk to me about security and compliance. I went online and saw a YouTube or a TED Talk." Um, I'm glad you did. I love the fact you're informed, but let me give you a more holistic approach, right? And I promise I won't quote WebMD when I go, for my appointment with you.
That's like Jennifer. That's like Zoom. No, was it a legal Zoom? Is that right? All right, guys. My last question, and this leads a little bit into our webinar next month, which is August 18th. We're going to have John and also a cyber insurance specialist on talking about the need of having a cyber insurance policy. But while we've got the attorney, we've got John on, why should a healthcare practice have cyber security insurance, and how are the lawsuits handled when they don't have one in place, or they've lied about it, or maybe not necessarily lied, but provided information on the form that they were not aware that they were filling out correctly or not?
John, why don't you take all that part first from your
Sure.
perspective?
Like Jen said earlier, you file a claim, insurance companies in the auto world have decades of actuary tables. They know exactly what type of accident should cost what amount. If you ask for an amount that's normal, the two parties, they don't even hit mediation, right? If it's a little bit over, they mediate. If it's a lot over, they go to court. Cyber insurance a year and a half ago, was keeping 70 cents of every dollar spent on policies. Now they're keeping 30 cents. They don't have decades of actuary tables. The insurance underwriters have no idea what to charge and what things are going to cost. So they are very, very, very different than malpractice insurance or car insurance. They're not prepared to simply pay a certain percentage. So if you want to know that your claim is getting paid, the first step is when you fill out that underwriting, that questionnaire, you've got to know the difference between enabled and enforced. You've got to know the difference between endpoint detection versus endpoint detection and response. And I don't expect you as a podiatrist or to know that stuff. I expect you to send me a copy of your insurance form and let me fill it out with you and help you understand the answers you're providing.
And I think that's critical because I wouldn't know the answers to those either. And I've been practicing in IT for ages. I think it's wise to have, an MSP or your IT expert walking through with you as you fill those out. Because anytime you fill those out wrong, it's the first thing the insurance company is going to point to not pay your claim. Anytime you say you're doing anything in there and there's a gap in what you're actually doing, they're going to call that cyber malpractice. And you're not doing what you say you're doing, tantamount to fraud, they're not going to pay your claim. If you don't have cyber insurance, you're going to have to pay any costs associated with that, which could be extensive.
And
So-
then sorry, go ahead, Jennifer.
So I just think, cyber insurance is critical in this day and age. If you're working in electronic files, most of you probably are, as most people are. Who knows if the cyber insurance industry is actually going to stay around, because it's so popular right now, it's eventually going to become unaffordable. But while it's here, while it's available, I would recommend you have it, but make sure that your compliance is in line so that they don't just try to not pay.
And the insurance companies, the first thing they're going to do once you've contacted them, they're going to send one of me out that's going to plug into your network, and they are going to immediately start evaluating that those controls you said were in place on that cyber insurance form are there.
Yep. No, and Bo, you've done that a few times.
I've done that quite a few times.
Well, guys, I thank you so much for being on the webinar today. I wanted to educate you guys on the difference and what's out there new for 2022 and what's to come in compliancy. And I want to give you guys a complimentary security risk assessment with John. You can use the link here. We'll put it in the chat, as well as there's a QR code. It's free, no charge to you. Please sit down with him. let him review things with you and go over some of the things that you have going on, and let us make those recommendations. No obligation to buy anything, but I think you'll get a lot of value out of meeting with John for that. And as well, if you want to contact any of us, our phone numbers are here. My direct email, John, Jennifer, contact information is here. If you want a compliancy attorney that can bounce things off of, or you need someone on that speed dial, Jennifer is there for you as well. So all our phone numbers and contact information there. And then, as always, here's a QR code. If you need to reach out to me for any questions at all, feel free to email me, call me. I'll be glad to sit down with you as well. But I will probably bring the brains with John and Bo and Jennifer to the table to have this compliancy conversation for you. John, Bo, Jennifer, thank you guys so much for coming on today. Audience, thank you for being here, and I hope you take us up on the offer to meeting with John. Have a wonderful afternoon.
Thanks so much, Will.
Bye-bye.
Enjoy the rest of your day.
Bye.
Bye, everyone.